Hello, hello, hello. It is Friday. We're going to hear about some Sarah Boone. How is everybody? Thank you guys all so very, very much for being here. Now, I'm having a little bit of difficulty for some reason because I am not seeing the hearing on Law and Crime. Hold on a minute. But sometimes they do it. They schedule like, super quick, like right about the time, like maybe 30 minutes before. So I'm hoping that we see it soon. Okay. Now, let's talk a little bit about just some things before we get started on streaming the trial or the hearing. Hopefully, it is going to be aired live and not uploaded later. Okay. So, for those of you guys who've been asking, and I appreciate it so much, the concern that you all had, for me and for my family, and just really for all of Florida, let me tell you what happened. So, Hurricane Helene did her thing. She did linger in my part of the Floridas. I'm at the top above, on the, I'm in coastal Pasco County in Holiday. And so she did linger a little longer than they had anticipated. And there were a couple of times last night when I did get a little scared, and it does take a lot because I went through Irma. That was my very first hurricane, and that happened like the first year that we moved to Florida. So that was a little, but anyway, so she lingered. She had horrible winds. The winds were crazy, and the only way that I can describe the sound of the wind from inside of the house, it sounded like an airplane was just hovering over the house. That's what it sounded like. And I was watching out the office window, which was stupid. I should never have done that. But I did because I was checking. There's nothing in my backyard. There aren't any trees. So I was worried about the front, and I have palms, and they're close to the house. So I was looking at the palm in the front yard because God bless that little palm. I mean, it's an old palm. It's way, way huge up there. But anyway, that little palm was just a swaying back and forth, and I felt bad for that little palm tree. And the thing, it's not really a little palm tree. It's huge. It's super tall. But that's where there's some owls that live in that one, various little birds. And but anyway, as I was watching that, the sky lit up this weird, like somewhere, it wasn't green. And this was after sunset, like long after sunset. I'm telling you, like, I'm talking about like 8:30 maybe. But anyway, it lit up like this almost like turquoise, weird blue green color. And I've only ever seen that before when Irma came and a transformer blew. And I think that's what happened, but they were maybe on a different power grid because we didn't lose, thank God, we didn't lose electricity or anything like that. In fact, honestly, for us, it wasn't all, it was, there were moments when it was dicey, but it is, nothing at all like what other people experienced, what they went through, the damage that was done to their homes. There was loss of lives. I know that in my neighborhood, there were 2 homes that caught on fire. So, yeah, that was a bit scary. But I'm safe. I'm sound. It makes me anxious even just talking about what I saw. I mean, the color of the sky was so weird that I cannot describe what it looked like. And oh wow, Trulia, Sandkeep here is gone. See, this makes me sad because when these things happen, hurricanes, this is how I look at it. Okay. So I moved from Texas, right? That's where I lived and grew up in Texas since I was like 10 years old. Okay. And so one of the things about Texas is, when you live there, that every March through April, it's tornado season and severe thunderstorm season. Okay. And so you sort of just expect it. You kind of live with it. You know what to do. You understand, and you prepare, and that's all that you can do. And then when we moved to Florida, obviously the price you pay for having sunshine, 363 days of the year, right, is hurricanes. And especially when you live on the coast, and I live on the coast. And that is just the deal. And what you do is you prepare. And that's all that you can do unless you're in a mandatory evacuation. Now, I was not in a mandatory evacuation zone. I was in a voluntary. Now, I will tell you this, and this is a really common misnomer that I think even I didn't understand until I moved here. Okay. When you live here, because hurricanes happen, employers aren't always super gracious about allowing their employees to prepare. In point of fact, my husband was out in it yesterday in the afternoon as it started to really get bad. She was inching closer. She just skirted the coast of Florida, really, until she made landfall. But she's such a big storm that I'm okay, babe. I'm okay, Tinkerbell. But I think what people don't understand that live other places is that you can't always evacuate way ahead of the storm, because like I said, my husband was out in it yesterday until he didn't get home until 6 o'clock in the evening. And he made it home just in time, because I'm telling y'all, about 30 minutes later, if that, is when the wind started picking up. And I would also like to report that while there was a lot of talk about wind gusts, there was not a lot of talk about sustained winds. And I was under the impression, and let me also say, this is why I was under the impression. Your girl made it over there to the WFLA stream, and I was a hashtagging Hey JB and Hey Eric, and a dose of Jen Lou was a featured comment. I took a screenshot, and I screen recorded it, because it's just my little moment. But anyway, Eric was talking a lot about storm surge and tropical force winds, gusts. I'm here to tell you, as a first hand witness, we had sustained winds, and they were loud, and they were strong. Guys, I need your help. Seriously. I cannot freaking find this stream for this hearing. I don't know if they're not covering it. I don't know what is going on. I'm very upset about this. I need help. If anybody has the link to the stream, can you please email it to me, because I can't find it. Y'all know that. Remember that time somebody came in here and said, "Hey, have you seen the footage of Sarah back in the day when she was on one of those Nickelodeon games and your girl found it?" Usually I'm good at that kind of stuff. Okay, if we had flooding here in my neck of the woods, um, it we did have it, like my backyard was, had a lot of water in it, and none of the water came in, but it receded fairly quickly. Here, let me type it in the chat for you. Hang on a second. If I type and I talk at the same time, sometimes I can't do both. Just the magic that is me. Did I write that right? No. See? But anyway, I did make it to WFLA, and that was extremely exciting for me until I realized in my excitement to get this to be a featured commenter. I was taking the screenshot and worrying about screen recording it, right? And my then I had to go back after the fact and like rewind it and listen to what to the answer to my question. Are they okay? Other streams are having trouble finding the live stream. Okay. Now I will say this. I didn't make the news. I just was in a live stream on WFLA, and you know how on that when they live stream on YouTube, or on Facebook too, but I was watching through YouTube. How if you hashtag JB, or you hashtag Hey JB, or hashtag Hey Eric, you can get your comment featured on the program or your question, and my question did. So yes, I lived in the Metroplex. I grew up in Arlington, and yeah, those storms are absolutely no joke. Yeah, but I can't. I'm sure they are, but I cannot find the stream. I see, everything but that. Let me see. Let me look at trial. Let me click that. No. ¿Dónde está? Hold on. Let me see if somebody emailed me. Let me just check. I'm going to check all the things. Ooh, B Crumbs coming in clutch. Thank you, B Crumbs. All right. I am going to, how can I? Let me send it to myself really quickly. I'm sorry, you guys, for the lack of preparedness. This is not like me. Usually I'm pretty good at being ready, steady, go. But today, I don't know, I'm a little frazzled. I'm not going to lie. And I don't even really know why, to be honest with you, because what we got, yeah, I mean, there were moments, okay? And I'm not going to like pretend there wasn't, or it was no big deal or anything like that, because it was. There were some moments that truly, truly were scary. That's facts, okay? But in keeping it in perspective, seriously, I found it. I got it. Thank you. Seriously, like keeping it in perspective and everything, for me, yeah, there were moments of being scared and whatnot, and there were some really hellacious winds and everything like that, but there were people that lost everything. And then there are also people, which to me, everything means, like your life. Okay. But there were people that lost homes. And I know that Orlando, see the way that Florida shaped, and the way that Helene, came in and did we had a lot of things. There was a lot of moving parts to Helene yesterday. And so like the other places and like Orlando and stuff more inland got a lot of, they were under the threat of tornadoes. And so I don't know what it's going to be like right now in Orlando. We're still getting, even here, gusts. And I was like, they were showing I kept it on WFLA, and I would try to like watch other things to get myself because if I hyper focus, then it's not a good idea either. Like, I knew that I had done everything that I could do. I prepared for the things. That's what I was supposed to do. And so what else, what more could I do? You know what I mean? And I didn't want to like sit there and continue to watch on it and, like whip myself up into some type of frenzy, because that's also very on brand for your girl. Okay. That's just me. It's part of the deal. And I didn't want to do that. So I visited Allie's channel, Alex Erickson. She went over some things with an interview with Madeline Soto's biological father from law enforcement, or with law enforcement. There were a lot of interesting things that Madeline's biological father had to say. And so I thought, if you've been following that case at all, and you may have missed her live yesterday about that yesterday afternoon, definitely go back and check that out. Also, this morning she did Alex Erickson did a fantastic live on she does true crime news this morning, and if you missed that, it was a really good live. And yesterday around 5 my time, so if you're interested in Delphi criminality, Teresa did a fantastic job. She had a fantastic live on Delphi yesterday. So if you're following that case, definitely go check out criminality. Okay, so Sunset, you're going to be today's on-air correspondent, live and from the area. So Sunset says, I live in Orlando, 1.5 miles from courthouse. It's sunny, some clouds. Neighborhood's power still out. I'm in Conway, never lost power. Well, I'm glad you didn't lose power. It looks, I updated or looked and refreshed the Orange County courthouse, or, the clerk of courts. OMG. There's some filings that have taken place today. So let's see what this is. All right. They comes now the state of Florida by and through the undersigned assistant state attorney, and gives notice that copy of below listed digital evidence has been disclosed to James Owens, mailed through the U.S. Postal Service on September 27th, 2024, disc number 9, Brady, Detective Copsel. That's the female cop. Okay, let's see what else she's got filed over here. Notice of provision, witness list. Ooh. Hold on a second. Un momentito, por favor. We've already been through the let's see. All right, let's go through this. Let me share the screen for you guys. Just while we wait. Okay. Let's see here. Make this bigger for myself. Maybe not that big. Okay. State's preliminary objections to defendant's amended exhibit list comes now the state of Florida. They received on September 26, 7:21 p.m., the state received an amended exhibit list from the defendant. This is outside the scope of the time frame the defendant was allowed to list exhibits, but the court granted leeway for a potential extension. The potential admissibility of battered spouse evidence has changed the feasibility of all the court's deadlines in its scheduling order from August 5th, 2024. Items 1 through 3, which the defendant does not even have yet, will likely require hearsay, relevance, and 90.403 objections to be made, resulting in either their exclusion or voluminous redactions to be made. Okay. We're going to read this and then we're going to figure out what it is that they're responding to. Also, these records may require the battered spouse syndrome experts to have to re-examine the defendant and potentially be redeposed. Items 4 through 7 are police reports. Police reports are inadmissible hearsay in Florida. It's unclear whether the defendant believes she can use these reports in her case in chief or for potential rebuttal. The latter may provide some limited admissibility. Reliance on inadmissible evidence by experts is permissible, but it does not make the inadmissible evidence admissible. Regarding items 8 through 11, the state notifies the defendant that it will potentially use photographs of George Torres's injuries as well. This will also involve the testimony of the deputies who observed George Torres's injuries during those prior incidents. Item 12 includes inadmissible hearsay from the defendant. Item 13 is inadmissible character evidence under Florida statute 90.404. Oh, this is the criminal rules, criminal proceeding rules. It's the 404 where the evidence is deemed more prejudicial than probative. If the defendant does testify that she used justifiable deadly force against George Torres on the evening she killed him, she is permitted to testify to prior acts of violence committed by George Torres that she was aware of. This, however, does not allow a rap sheet to be admitted into evidence. Okay, so let's talk about this just a second, okay, because this is important. Hold on, let me check over here really quickly. Okay. This is important, okay? If they're trying to get in evidence of prior bad acts by the victim, because remember, the victim is not on trial here, okay? And if she's going to use the battered spouse defense, which she seems like she's gonna, right? Then in order to be able to talk about what George did to her and how that made her feel, then they're saying she's got to get up on the stand and testify to that. Otherwise, that evidence doesn't come in because it is not admissible under 404. Okay. Item 14 is another police report, which is inadmissible as explained above. Item 15 is inadmissible character evidence. The attacks on the decedent's character in a self-defense case are limited to reputation for violence, evidence, and specific acts of violence which the decedent committed that the defendant is aware of. Item 16 is irrelevant and likely filled with hearsay. That dramatic emphasis was added by me. The state has not been provided this information. Items 17 and 18 are irrelevant and inadmissible. Item 19A through O are inadmissible hearsay. In the 911 calls, the undersigned has heard from June 18, 2019 and September 4th, 2019. The defendant makes it clear to the dispatcher that this is, quote, not an emergency. And these statements are not excited utterances. They are merely, geez, Jen, inadmissible, self-serving hearsay. The remainder of the calls were not potentially relevant to this case until the defendant alleged the relevance of battered spouse syndrome evidence and have not been reviewed by the state. Item number 20 does not appear to be relevant other than showing that the defendant has no injuries. Number 15, unless otherwise noted below, the state does not have any preliminary objections at this time to items 21 through 51 without waiving any potential objections as the trial develops and not waiving the predicate for a photograph/movie being required prior to these items being admitted into evidence. 16, items 25 through 28, irrelevant. Items 23, 34, 35, 36, 38 are duplicative. Item number 41, irrelevant. Items 33 and 43 are duplicative. Item 48 contains inadmissible hearsay. 21, item number 51 contains inadmissible hearsay. All right, so let me see what they have provided here, because they said it's on the 26th, and this is their, hold on a minute, a provisional. It's not this. All right. It's not this either. I'm trying to find what they admitted, because I don't see it. Well, let me scroll up and make sure that I read this correctly. Yeah, September 26th. I was okay. I can read. I'm literate. I'm getting it right. I don't. That's what I already went over. Huh. There is a motion for a right to hair, cosmetics, and civilian clothing without restraints for the trial. There's another response. Ooh, but I can't get to these. Why can't I get to these? There's another response by the state. Motion to strike defendant's motion to suppress statements at Orange County Sheriff's Office, and motion to strike defendant's motion, hold on, to suppress statements at OCO. Okay, this trial isn't, they're not live. Let me go over here to YouTube and just check it out. All right, let's see what you guys think. Let's see what else we got over here, because I can't, there's some documents for whatever reason that while they're there, they're not like clickable. So I can't look at them. I can see that there are pages of them. They're not labeled as confidential or visible on request or anything like that. But for whatever reason, I cannot get them. So that's unfortunate. I only see the state's response. I don't see anything that the defense filed, which is why this hearing and being able to watch this hearing is super important, because quite frankly, I don't know what they are, which, I mean, let me be honest. Let me just say something here. It's nosy. Like, I'm nosy. I want to know what the deal is. Okay. I want to know, what they're trying to get in. Okay, so it seems like, okay, so that link that you sent me, B Crumbs, they are not streaming, and they will upload the trial or the hearing when it's over, and the hearing is taking place. So hang on. Perhaps it's going to be something that is going to be done and then uploaded later because y'all, I'm serious. I can't find it. The only thing, let me look at Fox 35 Orlando. They sometimes have it too. Let me see if they have it. Let me see. Bruh, where is this hearing and why is it not? All right, let's go to long crime and see if they have it. All right, let me check. Let me see this. No. I'm sorry, you guys. I mean, this has never been an issue before. I don't know what's going on. All right. Well, let's see. Let's Google Sarah Boone hearing today and see what happens. Let's see. And what's interesting is yesterday, while MK, I'm done with you. I don't hear anything. Finally, no commentary. Woohoo! Red letter day. Okay, so I guess that's what I'm thinking too. Curious, Christine. It's still happening and will be uploaded later, but no live due to the storms, is what I read. Okay, so let's do this. I feel like I can't have a meaningful conversation about what this the state is objecting to about with respect to their exhibits, because I can't even see their exhibits. I can't see what they filed. Like I can't click on it. It's, let me refresh this and see if maybe baby it's been, oh, I got them. Yeah, it did get updated a little bit. Un momentito. Let's read about this motion for hair and cosmetics. Following. All right. I will definitely be back later tonight. Don't worry. I mean, we're going to go over these motions and stuff, and I'm going to chill with you guys. This is a more in this hearing. Okay. First of all, let's just take a breath, Jen. Just get your life together. Get yourself right. Okay. So here's the deal with with this hearing. This is the final hearing, potentially, depending on what's said and what happens in this hearing, right? This is potentially the last hearing that will occur prior to the trial. Okay. There might be one more. But, as far as that goes, this is pretty much, this hearing is important. And it's important for a couple of reasons. One, the main thing that's important in this whole situation is that Owens which is Sarah Boone's attorney, he filed over the weekend, which I covered. He filed a motion to suppress the interrogation video, and that is huge. Okay. Does it mean if the judge agrees with Owens that her constitutional rights were violated, and that she did not give that statement knowingly and voluntarily, that there was coercive in nature, as has been alleged, does that mean that all hope is lost? No. And here's why. In my opinion, again, I'm not an attorney, but in my opinion, the reason that not all hope is lost is because there's still, although he did bring up the statement that she gave prior, that she gave the day prior in the detective's vehicle, okay, that there's that. And there is also the body cam footage from the from the patrol officer who responded to the initial 911 call. Okay. So there's that. We have her body cam footage. That's admissible because that she doesn't need to be Mirandized or anything like that. So all is not lost. Do I think that the judge is going to allow that to be suppressed? No, because I don't think that the statements that she gave, I don't think she was coerced in any way. I don't think she was promised in any way anything in to give that statement. The If the allegation is that Sarah was told to come down to the station and to be able to retrieve her phone, okay, and she came down there, and then they said to her, we have some questions because we've got some preliminary results in his autopsy, and she sat down there and talked. At no time did she ever even ask A, for an attorney, or B, if she was free to leave until the very end. So I just don't think that the judge is going to find that way. All right, so let's see what this right to mo- I can't, you guys. I know I shouldn't be laughing. Listen, I'll say this, okay? Let me just get my life. Let me just get right. Okay. The thing is, this is a very frequent request. The request for the defendant to be allowed to appear in court in street clothes. And here's why. The reason that it is often granted is because the defendant, in this case, Sarah Boone, has the presumption of innocence. Okay. She's not been convicted of a crime. And so to have a defendant come to court in a jail uniform is prejudicial to the jury. And so I've never ever seen it. I've never seen a judge deny a defendant the right to appear in street clothes. And let's take that a step further. If you're following Idaho versus Brian Kohberger, Brian Kohberger's attorney asked that he be allowed to appear in street clothes in all preliminary hearings. So there's that. Okay. So let's read this. I've not ever seen a motion, though, for makeup and hair. Okay. Sarah wants her hairs did. All right, here we go. The defendant bind through the undersigned counsel moves this honorable court for an order permitting defendant to appear in all court proceedings pertaining to trial in civilian clothes without restraints instead of jail uniform. In addition, the defendant requests that she be permitted the right to having her hair styled and access to makeup. In support thereof, defendant states the following. Statement of facts. Defendant is presently incarcerated and is scheduled for trial October 7th, 2024. The defendant has been incarcerated for over 4 years, and the defense would like access to professional hairstyling, cosmetics, and civilian clothing without restraints throughout the defendant's trial appearance in respect for the court and prospective jurors. Without the court entering an order permitting her access to such, the right to receive a fair trial would be impermissibly infringed upon. Ooh, legal argument, which is basically what I just said. The presumption of innocence is a basic component of the fundamental right to a fair trial. Okay. Right to appear without physical restraints. This is stuff that's already been the court's right to appearance in the courtroom before the jury. This is all normal stuff, and stuff actually that the judge has already ruled on. Okay. What did the judge? Sarah asked for no restraints. Okay. And what is the order? The judge said, after a hearing, he said, hey, yeah, you don't need to be restrained during trial. We're going to give you the what did they call it? It's a shock apparatus around your ankle. Okay. And then after getting that, okay, the court liaison, okay, with the public defender's office, who was providing Sarah with outfit choices for her trial, okay. The judge said, here comes Sarah talking about why I want to wear a skirt. And the judge is like, look, Sarah, this was when she was pro se. If you want to wear a skirt, that's fine, but you need to understand that the shock ankle apparatus, which I know there's an actual name for that, but right now I can't remember it, and I'm sorry about that. So, excuse me. Anyway, he said, bruh, that's going to be visible. If you're okay with that, if you like it, I love it. Just as long as you understand that that's the deal. Okay. And when I don't even think that Lori Vallow asked for hair and makeup. She did ask to be able to wear street clothes. That's true. But I don't think she asked to have her hair done and her makeup done, because let's be honest, okay? I don't know what she was using, but it's been my suspicion that Lori was using hot Cheeto dust for both blush and lipstick, okay? So I feel like whatever, she didn't even ask for it. And I feel like, oh, hang on a minute. Wrong one. Sorry, I got too excited for no reason. My bad. I'm sorry. What the heck? Hold on. Let me check this other source out. I guess they're going to upload it. Let's see how long it goes, though. 'Cause I'm kind of curious. All right. Let's see. Hold on. I'm looking at something, you guys. Give me just a second. Okay. Anyway, so and listen, I get it. Sarah has been incarcerated awaiting trial for 4 years and 7 months, maybe a little bit longer now. That's true. That's a fact. In that time, she went in with one hairdo, as we can see from her initial mugshot. Okay. And clearly, we can see through the evolution of the mugshots over the 4 years, right, that her hair has not grown. It's gone the opposite way. It's shorter, which would imply that she got a haircut in jail. Okay. And so I'm going to listen, even if Sarah's granted hair and makeup, okay, there's only so much that you can do with that hairstyle. Okay. That's just facts. Having access to a brush, a blow dryer, a flat iron, hell, even a curling wand is not a magic wand. Okay. It is going to be what it is. However, I understand her request. And I can't imagine that she's not going to get it. Now, Allie asks, hey, babe, how long is her trial expected to last? Well, it was scheduled out initially when she was pro se to be a 3 week trial. Okay. And now it's but at the last hearing, Owen said like 2 weeks. He was thinking the whole thing could be in 2 weeks. And he also thought that they could seat a jury in one day, which means theoretically, if he's correct and they can seat a jury in one day, which the jury is scheduled to appear for jury duty on October 7th. And that means that if they can get a jury seated on October 7th, then the opening statements of the trial and the part that we're allowed to watch would begin October 8th. And it is supposed to last. It is supposed to last 2 weeks. Let me read this better. Okay. Let me just see what she would like access to professional hairstyling, cosmetics, and I didn't miss that part, or I know I read it, but I guess it didn't sink in. Professional hairstyling. Is she kidding? Is she kidding, y'all? She wants a hairstylist to come in? Now I can see the judge granting her civilian clothes because he already did. I can see the judge even granting her access to makeup. Okay. But I cannot, I just feel like, okay, let's think about this in terms of how this could be accomplished. All right. I mean, she's likely going to be held like at the courthouse. They have a place for people who are on trial, because that's where they hang out before the hearings and stuff like that. So, I mean, I think they do at most courthouses. I have to look that up about Orange County, but even, so let's say that's the deal. So who's paying for this? Thank you, RJ Mercy. That's where my brain went to. Who's paying for this? Okay. Is it going to be Owens? Is that part of his pro bono? Because I can assure you, me too. Where's MK Helene? I volunteer MK Helene to go in there and do Sarah Boone's hairs. Okay. Because I'm sorry. I mean, I'm close. Hey, maybe I should offer my services. I'm not I don't have a cosmetology license, but I know how to work a hair dryer, a brush, and a flat iron. I ain't promising miracles, okay, with that hairdo, but I mean, at least I can give her some volume. I mean, hang on just a second, you guys. Let me shut the door really quick because my husband's coming home and it's loud. Be right back. Okay. But yeah, can you, let's just sit here and think about this for a second. Okay. A professional stylist. Well, again, I say, who's going to pay for this? The taxpayers. We have already shelled out. Okay. 15 grand times 3 for her previous attorneys. Plus, Mr. Padilla, Florida taxpayers paid for him as well. We have been paying for more than one expert witness to come in on Sarah's behalf, although we are just now going to trial. Okay. We are paying for a private investigator to find, witnesses, all the things that private investigators do. We are paying for, what else are we paying for? An additional psychiatrist to come in and testify, and a crime scene death reconstructionist. So a death investigation reconstructionist. That's how you say it. Sorry. I know how to speak. My bad. Okay. How much more are the taxpayers of the state of Florida supposed to shell out for Sarah Boone? And this is why I'm incensed by the professional element, right? Saying it's one thing that if she wants access to a hair, a blow dryer, a brush, even a roll brush, and a curling wand or a flat iron or something. Okay, that if she's going to do her own hair, right? I don't have an issue with that. That's not a big deal. Okay. What I have an issue with is who's going to pay for this, especially given the stuff that we heard from Ms. Cashman, Mr. Bankowitz, and Mr. Hobson relating to their time as her attorney and what they had to endure and what their staff and I remember Mr. Bankowitz talked about his family in a prior hearing, what they were subjected to, what they had to endure. Okay. And now we're where we are today because of one person and one person only, Sarah Catherine Boone. Okay. That is why we're here today. That is why it has taken 4 years and 7 months for her trial to begin, because she wanted things done only her way or the highway. Uh-oh, hold on a minute, you guys. My hair is tangled up in my headphones. And she was not going to stop until she got it her way. She put any attorney who told her not what she wanted to hear, but what she needed to hear, which is, looky here, ma'am. The case is the case. You got in there. They are going to present these witnesses, and this is what these witnesses, given their statements to police, this is what they're likely going to testify to. It ain't looking good, Shug. Okay. That is what that's what they told her, which is what she needed to hear. And it probably isn't what she wanted to hear, but it was the truth. Okay. And instead of putting her big girl chonies on and accepting the situation for the way it is and working under those, making the best out of a bad situation. No. She said, oh, okay. Well, let me tell you what I'm going to do. I'm going to go on the most furious, rude, defaming letter writing campaign the state of Florida has ever seen. And let's keep in mind here. This can't be stated enough. Okay. Florida is infamous for throwed off cases. I don't know another way to put it. Messed up cases, straight cases that involve strange circumstances. I mean, we have a website that's called Florida Man, for Pete's sake. Okay. So, this is, and here we go. Hold on a minute. I'm looking at something. So we know all of this, right? Like, This is Florida, okay? And these are, even for Florida, these are messed up circumstances. Like even Florida is shocked, okay? And she's caused this, all of this. There are people, and I want to keep this in perspective, because I've taken into consideration that at the time of Sarah's arrest, shortly after that, let me see, I believe it would have been either March or April. I feel like March is the answer, where the state of Florida shut down. We were all there in 2019 or 2020. We all know. Okay. We all remember. I don't need to rehash it. We were one of the last states to close and shut down and all that, and one of the first to reopen. And that's just the way it was. I'm not making a judgment on it one way or the other. I'm just stating facts. That's how it was. So she's arrested at the end of February. February 24th, 2020 is when she's arrested. Okay. Then we have the whole pandemic, the situation in 2020 that shut everything down. Okay. Charlie Adelson went to trial in 2023. He was arrested after Boone. He's already been to trial. His trial is over. He's been convicted, and he is now in the appeals process. He's been convicted, sentenced, and is in the process of appealing. Okay. Letitia Stout was arrested March 7th. No, that's when Gannon's body was found. The beginning of March 2020. Again, after Boone. And when she was arrested and charged with first degree, there was no body at that point. It was 2 weeks later, after she was arrested, that the 7th of March, that they found poor sweet Gannon's body. Okay. In Florida, by the way, which that presented its own hassles and delays. Okay. And Letitia herself delayed the trial and the trial process numerous times. Okay. First, she said, "You know what, Judge? There's a conflict between myself and my attorney, and so I'd like a hearing." So a hearing was granted, and they decided, and she decided she wanted to represent herself. Okay. And this is a hearing that was granted and heard by a separate judge from her trial attorney. Okay. So they heard her case. They listened to all the things, and they allowed her to represent herself. Okay. Then they make accommodations for her. She gets her discovery, all the things, on and on and on, yada, 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 whatever. Okay. And then then she says, "You know what, Judge? I think I might be out of my depth here. Hey, I would like to, I just changed my mind. I would like to be represented by counsel." And the judge is like, "Oh my God." But okay. So her standby counsel, as it were, they were appointed, and they represented her at trial. And initially her plea was not guilty. Then at the 11th hour, Letitia's attorney said, "We're changing our plea, and we're going to go with not guilty by reason of insanity." Okay. Which sorry, I was listening to something because I'm checking to see when when a stream of the trial or the hearing might be uploaded. Okay. So that presented its own issues, being, not guilty by reason of insanity, all the things, right? Even Letitia Stout went to trial, had a trial, got convicted, got sentenced, and was arrested and charged after Sarah Boone. Hell, Letitia has already started a whole lawsuit against the prison that she's currently being housed in. Okay? To keep it in perspective, there are a ton of people who were charged with a crime similar to Sarah Boone's that are far more complex cases than Sarah Boone's, who have already been to trial and are in the process of appeals currently. And yet, here Boone sits, okay, being the entire obstacle to this whole saga, okay, by her own behavior. And she's got the unmitigated gall, the audacity. Let me calm down. I feel like I'm really yelling. To have her paw out for a professional hairstylist. Girl, if you don't go sit down somewhere, Sarah Boone, ridiculous. Absolutely, completely, and totally ridiculous. I cannot even believe the nerve. A professional hairstylist. Are you kidding me? Are you kidding me? The fact that this man filed that with a straight face, I can't even. I'm serious. I don't know why this irritates me so much. It shouldn't. It shouldn't bother me. I should just let it go. I shouldn't be so annoyed by all of this, but dadgummit, I am. You know, I'm over it. Hold on a second. Okay. That's why I'm annoyed. I'm over it. Like I'm annoyed. I just can't. I'm just incensed by I support the presumption of innocence. I support our justice system. I support people's right to a fair trial in front of a jury of their peers. 100%. Okay. What I am annoyed with and by is, let's read this, is the audacity of the situation, what she's asking for. I think it goes so above and beyond um, what is standard, what we have decided as a society that ugh. Okay, so Jennifer M says, Jinlu, I just want to play devil's advocate. I love to play devil's advocate. Do you think that she's asking for someone to come and do her hair and makeup? Maybe it's a friend and she needs permission. Okay. So, that's very possible. That's a very good point. Um, I hold on. Let me read this a little bit more and see if he was more specific. He's not okay. Um, he's not specific in his request. And maybe it's possible that during the hearing he was more specific, and we'll have to wait and see for that hearing to be uploaded. Let me see if they've done anything yet. Hold on. Mm-mm. It's probably going to be much later. No. Yeah, I think it's going to be a minute. Okay. So let's read this motion and then I'm going to let you guys go and I will keep an eye out for it. I will watch. Um, I will watch and I'll go live tonight. Now I want to let you guys know. I don't know who else is going live tonight. I'm going to look, and I'll let you guys know before I get off of here. But tonight is going to be like a marathon live, okay? Because we're going to go over, obviously we're going to go over the hearing, and there's other things that I want to go over with you guys. Like I want us to be prepared for trial. And one of the things that I am 100, I know for a fact that I'm going over is I located the other roommate, Brandon's roommate, Vincent, who is the one that allegedly gave statements talking about an argument on the night of that he heard through the wall. So I want to definitely discuss that, okay, because that's important. But we're going to be okay. Live trial TV is in the process of uploading. Perfect. Thank you so much. So let's go ahead and read this motion and then I'll look for it. Okay. Did I add this to this? Yeah, I did. Okay, here we go. This is the state's motion to strike defendant's motion to suppress statements at the Orange County Sheriff's Office and the state's response to defendant's motion to suppress statements. It looks like it's the same thing, but let's just read it. All right. So this is what the assistant state attorney states and alleges as follows. The defendant's motion is legally insufficient. The defendant recites allegations of facts, but not why any particular fact or fact is an issue. The reasons for suppression, as required by Florida Rule of Criminal Procedure 3.19-190, is a boilerplate assertion that it violated the U.S. Constitution and the Florida Constitution. This is no different than stating a search was performed illegally and improperly and unlawfully. And they cite California, or they state state law, case law. Geez, Jen, sheesh. This last one is a motion to suppress that cited 11 authoritative cases was legally sufficient. The defendant has not cited even a single case that authorizes the court to grant her the relief she is requesting. The state is left in the dark about what specific issue or issues the defendant is claiming and what legal authority there might be for the court to grant the relief request. Now, I will say this. When we went over this the other day, last weekend, when this came out, when they put it up, when they filed this, they didn't state case law or what exactly all the things that the state is saying in this motion and their response right here. They didn't do any of that. And I'm just going to say it because I am annoyed with Mr. Owens, quite frankly. I don't like the way he plays ball. I don't like the cut of his jib at all. And so, but I am willing to hear his arguments. I just don't like him. I can listen and hear people's arguments and keep an open mind about what they're actually saying, even if I don't like them. And I don't like Owens. I'm not a fan. No me gusta. But I have to ask and raise the question, was this done somewhat intentionally? Did he write just enough in that motion for it to be taken for it to fall under in good faith, a good faith motion because of their belief, right? Because I did look up today if lawyers are allowed to lie. I know they're not, but I just wanted to make sure, and because I wanted to talk about that tonight too. Anyway, but he made a good faith motion, right? And so I think it's just enough. But I think it was intentional. I think he left some things out, and I think he was intentionally vague on purpose. That's just what I think. I think that I don't think he wanted the state to be prepared fully to have a ready argument for case law that the defense cited. That's just how I feel. Ooh, MK said I'm about to befriend Sarah on the machine. Call me M Kiosk. Love it. Do it. All right. All right. Let's get back to this. Let me do what I'm supposed to be doing. Oh, wait, hold on. Let me hide this comment so you guys can see. Sorry about that. All right. The state is left in the dark about what specific issue or issues the defendant is claiming and what legal authority there might be for the court to grant the relief she requests. The court should strike the motion as legally insufficient. 2, the state objects to any additional claims being raised at the hearing that were not specifically pled in the defendant's motion. 3, in paragraphs 5 and 6 of her motion, she alleges that she was detained for 14 hours. And during this time, she provided a statement to law enforcement. She does not challenge the admissibility of this statement. And according to Chavez versus State, 54 hours of detention does not make a statement involuntary. Paragraphs 7 and 8 of the defendant's motion allege that law enforcement asked for the defendant to turn over her phone and that she provided the means to unlock it to law enforcement. Bell versus State is informative on this issue if it is the defendant's position that this somehow rendered her statement the following day involuntary. Bell makes it clear that the police, having seized evidence from a suspect and the suspect knowing they have seized evidence from her, only goes toward the analysis as whether a future interrogation is custodial, not whether a future statement is involuntary. Because Miranda warnings were provided at the beginning of the interview the following day, this is not a relevant factor for the court to consider. Bell is also informative on the distinction between a Miranda violation and an involuntary statement, which will be discussed below. Paragraphs 9 through 11 of the defendant's motion imply that law enforcement was being deceptive in their manner of summoning for her for an interview she did not know was going to occur. Pursuant to Bell, this goes to one of the Ramirez factors in deciding whether Miranda warnings were required, not whether a statement is voluntary. This is different from the deception that would lead to an involuntary statement. The defendant receives no promises of hope, leniency, or misrepresentations about the law. Both the United States Supreme Court and the Florida Supreme Court have held that deception alone does not negate voluntariness. This includes misrepresenting a co-defendant's statement, false allegations that law enforcement could arrange a satellite system to put a defendant at the scene, exaggerating the amount of DNA evidence against the suspect, informing a suspect that law enforcement was investigating a missing person case rather than a homicide case, writing DNA evidence on a whiteboard in an interview room prior to any DNA analysis being performed, and false representation of physical evidence that does not exist. Luring the defendant to the sheriff's office under the guise of returning her phone to her, if that is in fact what happened, does not make the statement involuntary. It only goes toward whether Miranda should have been read, and it was. Paragraphs 12 and 13 also only go toward the first Ramirez factor as to whether Miranda should have been read to the defendant. She was led upstairs to one of the interview rooms in the sheriff's office by Detective Lowen, where an interrogation ensued after Miranda was read to the defendant. Now number 11, nor is there coercion, although the defendant has not specifically made that claim or cited authority. Martin versus State allegations that law enforcement, 1, threatened the suspect with the death penalty, 2, deluded the suspect as to what he could expect for himself from a jury if he confessed, 3, deceived the suspect as to the amount of time he had to cooperate with law enforcement, 4, promised their favorable testimony and use of their influence during his trial if he cooperated, and 5, promised to arrange a visit for him with his girlfriend if he cooperated, and 6, exploited his religious beliefs by relying on a version of the Christian burial interrogation technique does not render a statement involuntary. though it presented the very outer limit as to what tactics law enforcement may employ when performing a custodial interrogation. 12, although the defendant never states that part of the reason she believes her statement should be suppressed was the minimization of her Miranda warnings, nor cites any case law on the subject, the state infers that she believes there is an issue due to what she has underlined in paragraphs 15 of her motion. There are several cases addressing the issue of minimizing the importance of Miranda warnings, and these are the cases. 14, saying this is something I have to do is not minimizing according to Wright, which is analogous to Detective Copsel saying, I'm going to read you your rights again because we have to talk about that. We just have to do it. They were read in normal cadence like in Chafin. There was no delay in reading them. The defendant is not a juvenile, and there is no claim that she is of below average intelligence. Quite the contrary, Sarah excels at everything. She has been read her Miranda warnings the day before and acknowledged this. It is a defendant who says it is normal protocol. These statements by law enforcement did not render her waiver of the Miranda rights involuntary or her statement involuntary under a totality of circumstances and analysis. In the balance of paragraph 15 in her motion, the defendant outlines the Miranda warnings as they were given to her by Detective Copsel. Paragraphs 17 through 21 outline what she believes the sheriff's office Miranda card says and how it differs from what she was told by Detective Copsel. Interestingly, the defendant believes that this creates some sort of legal impediment to the admissibility of her 2-hour statement that day is not backed up by a single citation to any legal authority within or without the state of Florida's court system. Sorry. Instead, she makes a boilerplate assertion in paragraph 22 that her statement was involuntary and her waiver of her Miranda rights was involuntary. Fortunately for the state of Florida, there is case law on this issue. There is no specific way that Miranda warnings must be given, and with all due respect to the Orange County Sheriff's Office, they certainly do not have the authority to tell this court what sufficient Miranda warnings are. While the 4 required warnings have become embedded in police practice, the specific words used vary, and the Supreme Court has not dictated the words in which the essential information must be conveyed. So, Detective Copsel specifically instructed the defendant on each of her four Miranda rights. 1, the right to remain silent. 2, that anything can be used against her. 3, she had a right to an attorney before and during questioning. And 4, a lawyer could be appointed if she could not afford one. The detective then asked the defendant if she understood those rights, and the defendant said she did. State versus Owens is directly on point. There, the defendant was read the 4 Miranda rights, asked if he understood them, and asked if anyone had threatened him or promised him anything. There's no mention of any question about whether the defendant wanted to talk to law enforcement after he was given Miranda warnings. This is apparently the Federal Bureau of Investigation's Miranda warnings, which were described as exemplary. So basically, therefore, if the court does not strike the defendant's motion to suppress for being legally insufficient, it should deny it on its merits. If the court believes there was a Miranda violation, then the defendant's statements are still available for use during cross-examination. Only if the court finds the statements to be involuntary will the state be prohibited from using them in cross-examination. Okay, so there you have it. The state is like, bruh, no. Those statements were not involuntary. There wasn't coercion. None of that occurred, and we don't appreciate the implication. All right, so now let me check once more. Let's see. And if it's not uploaded yet, hold on a second. Let me go to this channel itself. Let me see. I'm looking to see if they've uploaded it yet. No, they haven't. All right. So this is what I'm going to do, you guys. I'm going to, oh Lord, we're there. Okay. Wow. All right. So I'm going to go ahead and end this live, and I will keep an eye out for the live to be, or the hearing to be uploaded. And then I will schedule a live for tonight, and we're going to talk about the hearing, and then we will talk about many, many other things. We're going to do like a whole trial prep because it's fast approaching. Also, just while I have you guys' attention, I made a post on my community tab. And if you haven't looked at it, please go look at it. It is regarding the Menendez case. I am in a huge quandary over how to cover that case fairly and ethically. I want to be fair to everybody involved because at the end of the day, two people lost their lives in a horrific manner. Okay. And I want to be sure to present all sides and be fair about it. And I'm not exactly sure how to do that. And I am really struggling with it. And so I posed a question at the end of that post. And I ask for you guys to tell me what it is that you want to learn about. What are you interested in hearing? Now, keeping in mind that the only available videoed testimony of Eric and Lyle or anybody that any trial is the 1993 trial. The 1996 trial, which is the trial they ultimately were convicted of first degree murder in, was not, cameras were barred. I am given to understand that there is a transcript of that trial out there, but a transcript is not the same as seeing the actual testimony, witnessing the person testify for themselves. And I would also like to just point out really quickly that in the 1996 trial, only Eric testified. Lyle did not testify. The other thing that I want you guys to think about is if you have or you plan to watch Monsters, okay, on Netflix, would you like me to go because there's been some statements made by Eric and by the extended family that the Monsters series was rooted in fantasy, that it's completely inaccurate, and they're very angry about it. And I was wondering if you guys maybe wanted me to go through not every single episode because I mean, I can, if you want me to, go through every single episode and talk about that episode as a whole, and go through the episode and talk about what if there are inaccuracies, what those inaccuracies are. But it's you guys are the ones that watch me, and I'm interested in what it is exactly that you're interested in and what you want to see, and I want to try to give that to you. That's why I'm asking you guys to go and read that post and leave your comments, because I genuinely want to know. And so that's that. So I'm going to let you guys go for now, and I will meet you guys back here tonight. I might have to go a little early. I don't want to stream on top of anybody, and I'm going to try not to. Okay. So I'm going to also have to check that out and see when people are streaming and all of those things. Okay. Ooh, would you, chicken? Could you be more specific about that? You want me to do you want me to read to you what it is that Eric is saying okay, I get what you mean. You want me to talk about first, you want to hear what Eric says, what it is that is untrue. basically Eric is claiming that the way that Lyle, his brother, was portrayed in the Netflix series was fantasy. That is not who Lyle is as a person, that he is doesn't act that way, doesn't behave that way. And Eric was angry because, and this is not a direct quote, but he did say something to the effect of Ryan Murphy was able to portray Jeffrey Dahmer in a way that people were sympathetic for a cannibalistic serial killer. And look what he did. And yet they have deemed my brother and I, who are the victims of SA at the hands of our parents, we're monsters. That's what he said. That's what he said. And so I think that the easiest way, or maybe the best way to do it with this, and you guys, again, let me know in the comment section on that post, is really for me to go through the episodes and just discuss them. And, you know, I want you to understand that I can't talk about every single thing that's portrayed in the series and be able to provide proof of something, whether it's inaccurate or accurate, and provide proofs, supporting my argument. Because as with everything, okay, some conversations that occurred, or portrayals of conversations that occurred, they may not have actually occurred. And if they did occur, they're only between two people. And so how would I be able to vet that information? Like, if there's no recording of them or a transcript of them, I would have no way of knowing how accurately conversations were portrayed. But I'm going to do, I'm talking about not the Menendez trial so much, but the series Monsters, because, at first my approach was going to be, all right, let's just talk about the trial. Okay. Because at the end of the day, it is what's presented in court that the brothers have based their appeals on. Okay. However, the thing is, the first trial in 1993 resulted in both brothers had a hung jury, which then they got a mistrial. So then both of them were retried. And things that were allowed to come in 1993 were not allowed or limited in the way that they could come in 1996. And it wasn't, there were no cameras in the courtroom. So we don't have like video evidence of their testimony. So I can't really, like, the 1993 trial, almost, while it happened and it counts, it's not what they really base their appeals on, because it was a mistrial. So I don't, that's why now I'm thinking, but what I do see, and like, I watch some of these videos and stuff that are on YouTube about the show, and I read the comments on them, and I do continue to see that the series is wholly inaccurate. It's but nobody ever actually says that this episode, this scene is inaccurate, and leave it at that, or here's why it's inaccurate. You know what I mean? This is how it really went. So I thought maybe that would be a good place to start. I don't know, though. That's why I left that. That's why I made that post, because, man, I don't know. But anyway, now for reals, I'm going to let you guys go. I'm going to play out the outro and wish you a happy and safe rest of your Friday afternoon, and I will see y'all tonight. Okay? Thank you guys for being here. What a bummer it wasn't streamed. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you. No malicious intent or effort was
forte.
No militia.
Minutes later.
We all do a little mad sometimes.
And you know this, man.